I'm excited about this panel. We have ourselves a situation here with this case we're going to be looking at. One of the things that we notice is that it involves prayer and football, which usually was the case when I was playing football. Absolutely. And we have it at the 50-yard line after a game. And so it's going to bring in several clauses of the First Amendment. We're going to be talking about the free exercise clause. We're going to be talking about free speech. We're going to be talking also about the Establishment Clause. And one of the things that we'll notice is it involves a coach having prayer at the 50-yard line after the game. Now, the majority in a 6-3 decision with Justice Gorsuch writing for the majority is going to say that he should be able to do that. And we're going to look at, through our panelists, the interplay with those clauses that we just mentioned. The Free Exercise Clause, the Freedom of Speech Clause, and the Establishment Clause. And the majority says, yes, he should be able to, but the minority, the dissent, says no. In fact, not only does the dissent disagree with the majority on points of law, it disagrees with the majority on the facts as well. And you can see a picture they put forward there. And the argument is going to be, is this really, as the court said, personal religious observance going on, or is this something else? Well, I'm going to tempt you a little bit with those general facts, and our distinguished panelists are going to come up, and they're going to distinguish some of those points of law and also some of the facts for you. Please join me in welcoming our distinguished panelists. We will now hear from Professor Griffin, and then we will hear from Mr. Benson, and then we will have some time for questions and answers. Thank you.
Well, good afternoon. How's everyone? I want to thank the Center for sponsoring this. It's a great event. And I was reminded this morning to thank all the benefactors who have made the Center possible. And I want to thank also Director Brogdon for doing his new job so well. Dr. Griffin, no relationship, for moderating this panel. And Daniel Benson for participating on the panel with me. And I also want to thank Professor Burton, primarily because he was the first one who wrote me and told me about this conference, and so I'm grateful for that. Now, in addition, I wanted you to know that several of my UNLV law students are UVU grads, and one of whom's currently taking my law and religion class, and so they've told me how much they enjoyed the class. They couldn't come back for this one, but they send warm greetings to their alma mater. And I'm also fortunate to have one of my UNLV law students who regularly lives and works in Utah here this afternoon for the talk and for the whole conference. And so I hope it's a reminder to you, all of you, that you're always welcome at the University of Nevada, Las Vegas. Now, back in 1962, in the Engel case about school prayer, the court mentioned that prayer is a, quote, religious activity. Prayer has always been religious. Government has no business with prayer because of the Establishment Clause. That Engel court reminded us that government religion undermines individual religion, which is what the First Amendment is supposed to protect. Individual religion, not government religion. It mentioned how unconstitutional it is to coerce prayer. It criticized government attempts to coerce non-observing individuals or to put direct or indirect coercive pressure upon religious minorities to conform to the prevailing officially approved religion. A year later, Schempp, another prayer case, reached a similar conclusion about school prayer's unconstitutionality. Just for the record, at the time of Schempp, the court itself mentioned that there were 83 separate religious bodies, each with membership exceeding 50,000. The numbers were one reason for both the Schempp and the Engel courts to recognize and respect the separation of church and state. Prayer is for the religions and not for the government. Now, that's the straightforward way I look at it. The Establishment Clause means the government is not allowed to practice religion. Prayer is the practice of religion. There's no way for all the world's religions and non-religions to agree on what a prayer should be. Prayer divides religions, and if the government prays, it takes sides, either favoring one religion over another or favoring religion over non-religion. The Establishment Clause establishes that the government cannot prefer one religion over another or religion over non-religion. And it cannot do that so that everyone may have her own religion without any pressure from the government. Now, over the years, the court has not been that straightforward. They've introduced numerous Establishment Clause standards with many tests that the justices are always arguing about. And I can tell you, I always have my students going through all the tests because there are so many different tests, and the justices are never content with one another. And the Kennedy case is a good case for understanding that because the lower courts applied some of those tests. And so what were the tests? They used the Lemon test, the endorsement test, and the coercion test, all of which the justices had long argued about as appropriate interpretations of establishment. So the Lemon test. The case Lemon versus Kurtzman says that in order to survive establishment scrutiny, 1, the statute must have a secular purpose. 2, it can neither promote nor inhibit religion. And 3, there cannot be excessive government entanglement with religion. Coach Kennedy's prayer fails all 3 of those prongs. Why? First of all, because prayer is not secular. Second, prayer promotes religion. And finally, when the government is praying, it's excessively entangled with religion because it's practicing religion. Lemon is on the side of the school district. Now, endorsement was Justice Sandra Day O'Connor's test. She said the government may not endorse religion. Why not? Government endorsement of religion, in her words, sends a message to non-adherents that they are outsiders, not full members of the political community, and an accompanying message to adherents that they are insiders, favored members of the political community. She thought the Establishment Clause did not allow such favoritism, which Coach Kennedy was showing in his prayers. The prayer set up insiders and outsiders, those who would pray and those who would not pray. Now, coercion was Justice Kennedy's test, not Coach Kennedy's test, Justice Kennedy. And frankly, Justice Kennedy never liked Justice O'Connor's endorsement test. He preferred the coercion test. He said you could find coercion in the opinion he wrote about schools' prayers at graduation, right? Saying we've got to be aware of what's coercion and what's coercing people. Now, Coach Kennedy's prayer had the potential to coerce students to stay popular with their coach by joining him in prayer. And from one of the cases, the court said players, sometimes via their parents, reported feeling compelled to join Kennedy in prayer to stay connected with the team or ensure playing time. And there's no evidence of athletes praying in Kennedy's absence. The school district's lawyers said Kennedy had set up a system in which you might have to pray to play. Not praying might exclude you or affect your status. Now, I want to tell you that that description of the test saying that Kennedy acted unconstitutionally matches my experience as a professor at a public university, UNLV. If I started praying in my classroom, once class was over, or out in the hallway, there's no secular purpose, and I'd be promoting religion. That's Lemon versus Kurtzman. I think I would also be endorsing religion by engaging in it publicly where students could see me and join me, or not join me. That's the O'Connor endorsement test. I think some students might feel coerced to join me, to stay on my good side, maybe to get a better grade. The Establishment Clause doesn't allow me to encourage or coerce my students to be religious. And I have asked them about with that, and they do agree with me on that. They've had different reactions saying they wouldn't want to feel the pressure to join me in prayer or not to join me in prayer or face that kind of decision. Now, that's a different responsibility than I had when I taught at religious colleges and universities. Why? Because the Establishment Clause affects the government. And as a government employee, I cannot practice religion with my students. Now, those are the reasons why the lower courts, and of course the dissenters in the Supreme Court, stated clearly what was obvious. A government official is not supposed to be promoting or endorsing religion or coercing religious practice in the workplace. Now, Justice Gorsuch wrote that there was no evidence of coercion of the students to pray, which to me is an inadequate account of coercion. As Justice Sotomayor says in dissent, in her words, it's a nearly toothless version of the coercion analysis. In the past, the court acknowledged that students might be coerced if they were exposed to government prayer. Now, why get rid of Lemon, endorsement, coercion, and maybe the separation of church and state? Why get rid of all those tests? Maybe because you don't really believe in the Establishment Clause. You want more government religion. Now, Justice Gorsuch says this is a case about a coach's private prayer, but I don't think it is. And I want you all to know, just for the record, that I am a football fan. I'm a Notre Dame alumna from the Joe Montana era, and I was at that championship game. And I watched every minute recently of the recent Super Bowl. Why? Because Patrick Mahomes is the son of New York Mets pitcher, Pat Mahomes. And I've long been a New York Mets baseball fan. And so I want you to know that I've watched a lot of football, and I'm a football fan, even though a lot of my friends have given up on football. And so I think the dissent has a much more accurate picture of the facts, and that Justice Gorsuch, in the dissent's words, misconstrues the facts. And in her words, in the dissent's words, the record reveals that Kennedy had a long-standing practice of conducting demonstrative prayers on the 50-yard line of the football field. Kennedy consistently invited others to join his prayers, and for years led student athletes in prayer at the same time and location. And that's why it's the dissent that put the pictures of those prayer meetings in the opinion, just to make sure that there was evidence of the students, but not all the students, praying with Coach Kennedy. Now, the court ignores this history, and it is true in the first sentence of the opinion, Justice Gorsuch said Kennedy, quote, knelt at midfield after games. Now, for me, the midfield of a football field is never a private location where a coach goes to pray privately. It's something much more than that. So we can see that the court has gotten rid of a lot of these past Establishment Clause tests. What does the Establishment Clause now hold post-Bremerton? According to Gorsuch, in place of Lemon and the endorsement test, this court has instructed that the Establishment Clause must be interpreted by references to, quote, historical practices and understandings. In the past, the court acknowledged students might be coerced if they were exposed to government prayer. Instead, the court refused to protect students or to defend the separation of church and state. Justice Sotomayor addresses the problems with the majority decision very directly, even citing recent cases to show that a majority's arguments all lead to a bad conclusion. Ignoring precedent does not leave the court in a strong or persuasive position. She says the majority misconstrues the law as well as the facts, rejecting the valuable Lemon and endorsement tests in favor of history and tradition. Now, if you're like all my students, you've been talking about history and tradition for a while. Now, why is that? Because in the dissent in this case, Justice Sotomayor talks about the dangers of the history and tradition test. But everybody in common law has been debating the history and tradition test. Why? Because Dobbs, the abortion case, talked about resolving the issue by history and tradition. And of course, Bruin, the Second Amendment case, talked about history and tradition and trying to figure out gun rights. And there are stories of lower court judges trying to figure out, well, how do I apply this history and tradition test? And so I think the dissent is correct that the majority, in her words, weakens the backstop of the Establishment Clause. Now, this case will look to many readers and to many of you as if religious freedom has won again. Religion has won, but as the dissent says, as much as the court protests otherwise, today's decision is no victory for religious liberty. Why? Because it favors the government's religion over the individual's, and the Establishment Clause is supposed to stop that. In my view, the best history and tradition of the Establishment Clause is that the Constitution does not allow religious government. A praying government is a religious government. Religious government undermines every individual's religious liberty. So this case looks like it's protecting religious liberty, but it's not. It prefers government prayer to individual religious freedom, erasing the constitutional backstop that is supposed to protect the freedom of individuals to choose their own religion or to choose no religion at all. To promote that, the government must be secular, not promote in religion, not endorse religion, not coerce religion. The court has sometimes seen that, but in Kennedy versus Bremerton, in the name of history and tradition, it throws away what the Constitution is supposed to protect. So those are my thoughts about Kennedy and the Establishment Clause. Thanks for listening.
So I thought in talking about Kennedy versus Bremerton, it might be helpful to start with what are some things that I think we probably all agree on, and that the majority in this case and the dissent also agreed on. First, it's unconstitutional for the government to force you to pray. The majority and the dissent both agreed on that. I certainly agree with that. Second, the students who were on this football team at this school, they had the constitutional right to kneel and pray after their game if they wanted to. They also had the constitutional right not to do so if they didn't want to. I think that's another thing that we all agree on. The question then is, what counts as coercing those students into participating in a prayer that they didn't want to? What counts as forcing them to participate versus just allowing a coach who himself wanted to exercise his own faith to do so himself? Now, to this picture, the This picture was in the record. It was in the dissent's opinion. And this was a prior practice that Coach Kennedy had before this dispute arose, where he had given religious motivational speeches to his team, and that included prayer. And he also, in the past, had the practice of praying with the whole team in the locker room. Now, in both of those instances, I would agree. He was speaking in that instance as the government. And if the school told him you can't include religion in those acts when you're speaking in the name of the school, I think that makes a lot of sense. And that's why Coach Kennedy stopped doing that. And he agreed that he would no longer engage in those practices of gathering his whole team together, offering a prayer. He agreed, I'm not going to do that anymore. The practice that he was asking the court to protect going forward, and that he asked his employer to protect before he lost his job, was to allow him, after the team had shaken hands with the opposing team and other coaches, to kneel and give a brief, quiet prayer. And also not to feel like if there were other students around that he was forced to remove himself to somewhere where no one could see him. But what the school told him is, in order to comply with the Establishment Clause, you're not allowed to do anything that is visibly or demonstrably religious. Because if we allow you to give a prayer, even if you don't ask anyone else to join you, but if we let you do it yourself, then that is the same as the government sort of forcing other people to pray. But I think that looking at this case, there are three important principles that we can take away. First, religious expression is not something dangerous or shameful that we must protect people from being exposed to in the public view. It's a natural part of human culture and our nation's history and traditions. Second, seeing someone else express their own faith does not force me to join them. I remain free to join them or not, according to my own decision. Citizens in a diverse and democratic society, even young people, can and should be taught that it's okay to disagree on those questions. It's okay to express your faith if you want to, and not to if you don't want to. And three, the government's position in this instance, that it had to prohibit any kind of visible religious exercise, is particularly dangerous for many minority faiths that are less understood and that rely on many external, visible symbols in order to practice their faith. So the first principle let's look at, that religion isn't something that people need to be protected from being exposed to, but rather is a natural part of human culture and our nation's history and traditions. Dr. Griffin talked about the lemon test and the endorsement test, where in past cases, starting from the 70s, the court had said the government's not allowed to do anything that has the purpose or effect of advancing religion or endorsing religion. But there were a lot of problems with that. And the problems came out in how it was implemented. So a few examples. Hurricane Matthew devastates property, devastates people's lives. The government has programs to help people rebuild, to rebuild community centers that offer important services to the community. The government says, sure, if you're a community center, you can get a grant from the government to help you continue to contribute to your community, but not if you're a Jewish community center. Then you're excluded. And that decision came out under the Lemon and endorsement test. Another outcome of the Lemon and endorsement approach, a flagpole in the city of Boston. Virtually anyone was allowed to put up a flag. This was in front of City Hall. Virtually anyone was allowed to apply to put up a flag of their choice, to fly for a day or an hour or a few hours on this flagpole. Hundreds of flags were flown until someone said, well, I'd like to put a flag that has a cross on it. And the government said, no. Any flag goes, but not that one. And then coming to Kennedy, the practice that was at issue here, after they'd shaken hands and Coach Kennedy, for about 30 seconds, knelt to the field to offer a quiet prayer. It was undisputed. He was allowed in that moment to kneel to tie his shoe. He was allowed to pull out his phone, see who won the NFL game. He could call and make a dinner reservation. He could run up to the stands. He could talk to his wife, see how she was doing. He could do basically anything he wanted in that moment. but he was not allowed to kneel in quiet prayer if anyone could see him. If he wanted to pray, he had to go somewhere that he couldn't be seen. So those were some of the effects of the Lemon and endorsement test that the majority rejected in Coach Kennedy. Which brings to the second point. The principle adopted by the majority, as everyone agreed, if the students were being coerced into participating in a prayer, that would violate the Establishment Clause. But the question was, does seeing Coach Kennedy pray force them to join in his prayer if they don't want to? And the majority said no. And one of the reasons was because in a diverse society where people have different views, it's okay to disagree. If someone wants to pray, they can. If they don't want to pray, they don't have to. The district's position was they were forced to censor any of the coach's visible religious exercise. Otherwise, students who saw him express thanks to God would be coerced into praying as well. In other words, the only way that the school district could demonstrate to these high school students that every person is either free to pray if they want or not to pray if they don't want is to fire the coach who chose to offer a brief quiet prayer. In the school district's view, that was the only way that they could protect someone's right to pray or not to pray, was to fire the coach who chose to pray. And even stepping aside from the details of constitutional law, I don't think that principle reflects what we want our society to be. I think the principle that we want people to learn is that your expression of your opinion, your view, doesn't threaten mine. If students are in school to learn to be members of a democratic society, where they're in a pluralistic nation where people are very different, have different religious, have different political, have different ethnic and historical, and all these different aspects to them, I think we do our students a disservice if we convey to them that the only way to protect you from something that you disagree with is to hide it away. I think we help teach our students to be a part of a democratic society if we teach them, here's an example of someone expressing themselves. And it's okay if you agree with them, it's also okay if you don't. The school was in a position to teach these students about what it means to be a member of a democratic society, and I think the school failed when instead of teaching the students that it was okay for them to agree or to disagree with their coach, instead it said, well, the coach has to go. And I think when the majority said that there was no coercion here, that's what they were getting at. Just seeing Coach Kennedy stop and kneel and offer a 30-second prayer was not something that forced other students to participate in. They could join him if they chose to, but they were not required to. And in fact, in the 3 games that were actually at issue that he was disciplined for in this case, no students from his team joined his prayers. So at least in those instances, the students were able to learn that lesson, that the coach was able to offer his quiet prayer of gratitude, but that did not force any of the students to participate. And finally, my final point is the school district's position that they had to prohibit any kind of visible religious exercise in order to protect the students and their ability to not be coerced. This view that visible religious exercise is a threat to other people's rights is particularly dangerous for many minority faiths. If the test is whether someone else's religious activity is visible or whether someone else expressing their faith makes you uncomfortable, if that's the test for what the government has to prohibit or hide away, then that's a big problem for religions that require visible, outward religious expression. Take Islam, for example. Many women in Islam wear a hijab to cover their head. In prayer, Muslims kneel facing Mecca, and they touch their forehead to the ground, or their prayer mat that's between them to the ground. Their prayer may include a ritual hand washing, or face washing, or feet washing before their prayer. Some people seeing that would probably feel very uncomfortable because they'd never seen it before. It seems strange. And if your rule says only religious activity that's invisible is permissible in public, but nothing that's visible, then that's going to be a particular problem for those folks. Now take also Orthodox Jews. Many wear yarmulkes. They may also keep portions of their hair uncut. They may grow a beard for religious reasons. Orthodox Jews have lost their jobs, government jobs, because they refused to give up these symbols of their faith. And someone looking at that says, well, that makes me uncomfortable. I don't like seeing that expression of somebody's faith. Well, that's not coercing you to join them. That's just recognizing that it's allowed for people to be different and to express their faith in different ways. And a third example are Sikhs, or followers of Sikhism. Initiated Sikhs wear turbans, keep their hair unshorn, hair and beards. They wear a steel bracelet on their wrist called a kara, and carry a kirpan, which is a small ceremonial item that resembles a knife, but is not sharp and not dangerous. Now, I'll give an example of a woman named Ms. Tagore. She was an employee of the IRS, and she lost her job because her supervisor said, you're not allowed to bring your kirpan into work because it's a weapon. And there was a federal law that says no weapons were allowed in the federal building. Now, someone who saw her with her kirpan probably felt uncomfortable with that visible expression of her faith. But it was their misunderstanding of her faith that led them to think that it was a weapon. Because to a Sikh, a kirpan is not a weapon at all. It's a reminder of their devotion to God. And in fact, it's not dangerous because it's not even sharp. But a rule, again, that limits religious expression in public by public employees, depending on whether or not it's visible, is going to be particularly problematic for Sikhs like Ms. Tagore. Another instance that's recently been in courts involving Sikhs is Sikh men wanting to join the Marine Corps with their beards unshorn. And the government said, your external sign of your faith that's different from everyone else is a threat to the cohesion of your group. When you're not allowed to have a beard because it makes you different, you're not allowed to externally express your faith. And while the government in that instance was not relying on the Establishment Clause, the principle remains. If your rule is that visible expressions of your faith are a threat to those people around you who don't share your faith, then you're going to be much more skeptical of practices like those. Now, the fact remains that some of those visible expressions of religious faith may make people uncomfortable. And I don't doubt that some of the people who saw Coach Kennedy take a knee at the 50-yard line and give a brief prayer, I don't doubt their sincerity that they did feel uncomfortable at seeing him pray. But the point is, in a pluralistic society, we are all better off if we believe and teach our young people, like these high school students, that viewing this diversity of religious expression is not a threat to them, but is merely a reflection of the fact that each of us has the right to make the decision for ourselves what we believe and how we will practice that. And I believe, and even if we're wrong, we have the right to be wrong, and the government can't say one way or the other. And I believe that the majority in this case, in upholding Coach Kennedy's right to kneel and offer a brief, quiet prayer, vindicated that principle. Thank you.
What we're going to do now is we're going to switch to some questions and answers. Before we start going to the audience, though, I always like to give the opportunity to the panelists to see if they have a question for their fellow panelists. And so, Professor Griffin, we'll start with you.
No, I know.
No question. How about Daniel?
Yeah, one question. As we've talked about kind of the difference that the majority versus the dissent, the amount of importance that they gave to Coach Kennedy's prior practices, leading prayers with the whole team, either in the locker room or his religious speeches at midfield. The majority said, we're not saying that's okay. We're just saying that he's allowed now to have his own prayers. The dissent says, hey, you can't separate off his prior practices. You have to consider all of them together, even if he's now agreed to no longer do those things. So I'm wondering, Professor, from your perspective, had Coach Kennedy never had his prior practice of praying with the whole team in the locker room, and the first thing that ever happened was he approached his employer and said, hey, I plan to kneel for a 30-second prayer, and he didn't have that prior practice. Do you feel like that would have changed things, or do you still think?
Not for the dissent and not for me. And that's why I wanted you all to know I'm a football fan. I mean, I've watched a lot of football, and that's why I talked about my experience as a teacher. I mean, my identity really doesn't change the minute the class ends or when I walk out the door of my classroom. The students know still who I am, and I feel like my obligation carries over into, quote, non-official settings. And that's why I said it matters that if you think of a football coach being at the center of the football field, I don't think that means that he suddenly lost his coach's status as an employee of the government. I think the football coach in the middle of the football field, post-game, leading people in prayer is what I don't want government employees like him or like me doing. Why? Because I think government places have to be for everyone. And that starting to pray does not include everyone.
And I think the leading in prayer is probably where we would diverge in how we viewed this case. Because if you don't rely on his past practices that he had given up, then I don't view him as leading anyone in that moment where he knelt to offer the prayer. No one disputed that he was free if he chose to do any manner of things in that very brief period of time. So while it wasn't private in that other people were there and they could see, to me, that's what makes the difference.
In my experience, when somebody starts to pray, people who want to pray quickly join in. And so I don't think it stands to say, oh, he's there privately and it wouldn't have an effect on anybody else. I think that's what a football coach praying in the center of a football field do is invite those who, and I understand why you want those who want to feel welcome to participate in it. But I think that raises questions for all the people. Then we'll see, there are people who want to pray, and he'll remember the people who want to pray and the people who didn't pray and so forth. And so I think even if he's not leading prayer, that praying on the football field encourages some people who want to be with him to pray, and then sets up the whole controversy of who's going to be there, who's not. So even if he's not trying to lead people in prayer, I think prayer starts that. Because even in the last football story, people who weren't a member of his team came over and joined him. And so when people pray, other people who want to pray with them often do.
Can I just ask a question as well, then, just to help me to understand your position? I know that Sotomayor made a similar point as well. And so you're at a state university. Do you feel that you have the opportunity to pray, or do you not have an opportunity at all?
I could go into my office anytime I wanted.
Okay. So it's visible, whether it's visible or not?
And pray. But me praying alone in my office is not like me praying outside the door of my classroom. And I don't think it's like a coach praying on the football field. And my students were worried about this. We don't want to get rid of private prayer or of students praying or of people participating in prayer. But in my view, the Establishment Clause sets limits on government officials praying, because the Establishment Clause is very suspicious of government religion.
Mm-hmm. So if I understand correctly, then there's a visibility aspect here as well.
Mm-hmm.
So if you're by
I think
yourself
so.
in
Mm-hmm.
your office, you have the door closed, that's different.
Mm-hmm.
Okay. Do we have any other questions from our group? It looks like we do. And by the way, this is a great time to recognize our great constitutional studies students. If you've taken a constitutional studies course of public law, please raise your hand just to show folks. Yeah. Wonderful. Thank you very much. Please.
So in this particular case, moral quandaries are brought in. Does something, just because it's legal, mean it's moral, or vice versa, in your opinion?
So are you saying it's even if it's moral to pray, it doesn't mean it should be legal to pray?
Yes.
Right. Right. So I think the Establishment Clause sets up a legal distinction there.
Yeah. And then one follow-up. I noticed in the particular case it specified after, an acknowledgement of God after the fact of the game, rather than asking for help in the game. I think that's a distinction I thought was quite interesting because, for example, acknowledging God in that sense, do you think that would still be a promotion or rather an acknowledgement?
I mean, I think it's a promotion because everyone doesn't believe in God. They might have theistic beliefs but not believe in a God, or they might believe in several gods, or they might be non-believers. And that's why I said at the beginning, as hard as it might be to understand, in my view, prayer is not really something where you can get everybody to agree on the right language, because even appealing to God is going to antagonize some people.
Thank you for your presentations. As you were talking, I remembered the recent event, I guess not event, event's not the right word, but in the NFL, there was a player, Hamlin, who collapsed on the field, and a lot of the players spontaneously kneeled down and began praying. And I assume coaching staffs, people like that as well. So just picturing this scenario, of course, it's the NFL, so it's not the government. So we're not talking about whether people were coerced or not with the Establishment Clause, but I imagine that most people who viewed that didn't feel necessarily coerced to pray, or if they did, they didn't have anybody to sue, at least, right? But if we take that scenario and we move it to a high school football field, and let's say somebody collapses on the field and the same thing happens, all of the players spontaneously kneel down and begin praying, and maybe even the coaching staff. In that case, if somebody, so I'm primarily addressing you, Dr. Griffin, but in that case, if somebody saw the coach praying, they would be able to sue, right? And say, so it seems under your test, because he's visibly praying, even if it was spontaneous in that case. So I'm just wondering, in your view, why does it create greater religious liberty for prohibiting that coach in that instance from praying, whereas if we're in the NFL scenario in front of, like everybody in the country watching, and the same thing happens, they can do it, but a high school teacher can't. Does that kind of make sense?
Well, but it is different that not every person you're not always a government official. And that's what I meant when I said anytime I wanted, I could go to my office to pray, and there's no ban on that. And so you say, how do people react to a horrible injury that's worse than what people say? Then you could say you celebrate that all these private people from different religions are coming together. I mean, right? So it's not that the Constitution doesn't protect free exercise. What it protects you against is government officials kind of going out and starting to pray because, oh, we can pray, and maybe in the past you've joined me, maybe you will, maybe you won't. But to me, those facts are completely different. You're saying, well, people react to a health catastrophe in very different ways. And most people I wouldn't be standing there wondering if the Establishment Clause was violated. I would be worrying about the person's health and figuring in those circumstances, everybody reacts according to their religion or non-religion or whatever religion. But that's not what happens when you're a government official in charge of a group.
Yeah, I think there are kind of two questions that raises. One, when the coach is offering a prayer, is he speaking for the government? And in this instance, where it was undisputed that for those brief 30 seconds that he was allowed to do any number of things other than interact with his players, it's very difficult to say that in that moment he was speaking for the government.
He's on a government job.
Well,
Everyone
if
right.
simply having the government job means that every word that comes out of your mouth is the government's speech, then no government official, when they're having their lunch, is allowed to bow their head or cross themselves to offer a prayer. I
Well,
think,
having lunch isn't being on the job.
and neither were those 30 seconds when he was allowed.
He
to
was
do
in the
any-
middle of the football field immediately post game. In my view, that's you're still on the job, which is different from your circumstance where people are there reacting to somebody who's in serious health. I mean, in my view, being a government employee does bring certain responsibilities with you when you're on the job, and that's what the Establishment Clause is supposed to make our behavior welcome to everyone.
Just in response to that, ma'am, what about Congress when they convene, like at the State of the Union, and somebody gives a prayer? Everybody who's inside the halls that has been invited to Congress, aren't they on government time? So what's the difference of our elected leaders doing it versus a coach on a football field?
Well, because the Supreme Court has said in Marsh and Town of Greece that they're not afraid of public religion. And that, right, and so you could say that the Coach Kennedy case is consistent with March and Town of Greece in saying public religion is a good thing. My view is that you can't really find anything that unifies people in those situations. But you're right that Congress's prayer does raise that. But I think part of the problem of these cases is that and you saw this in the Town of Greece case, which was about whether the Town of Greece could have public prayer. And there wasn't really a strict separationist there who just said no prayer in government. Justice Kagan said you've got to have every religion present for it to pass the Constitution. My view is you can never really get to the point where you have every religion present. And so it's better to be separationist.
And just to follow up on that, ma'am, what about like if I get invited in and I'm an atheist and the government forces me to participate in that prayer? Isn't that the same as coercing me? The same
Yes.
as those students? So what's the
Yes,
difference?
but atheists don't usually win a lot of opinions in court. But the Establishment Clause does protect people of no religion, right? The Establishment
Right.
Clause says you're not supposed to prefer religion to non-religion.
Right.
But of course, my view is that there are almost always people who don't want to follow the Establishment Clause. That's why we have it, right? The lesson of the Establishment Clause is it comes from the wars of religion, where the religions could never agree on anything. And so, right, if you protect everybody, you've got a different kind of government.
So I was just interested in what you said about you praying the difference between you praying in your office versus the classroom. So I went to a state university, and in that building where I went to school, there was a meditation room. So anyone could go to the meditation room, but the school provided prayer rugs for Islamic students. So by the school providing prayer rugs in a it's a public room. Anyone can go there. The professors can go there. The students can go there. Is that a public place that you have? Is the University of Colorado violating, that separation?
I mean, the court cases have made clear that you can't discriminate against religious groups and funding. So most of the court cases have said that the religions get the funding there because the government can't favor non-religion over religious groups. So most of the court cases have gone for an equal access theory, saying if religious people want access to the university facilities, then they should have them. But as a way of promoting the free exercise of the students.
Okay, so the difference then, can you explain the difference between praying in a meditation room or like a private? It's not really a public room versus the football field. I'm not sure I see the distinction there.
I mean, if I went into my view is if I went into our prayer room and led prayer, that I would still be violating the Establishment Clause because I'm a representative of the government. But people going in there to pray doesn't. But you carry a different burden when you're a government employee.
So no
And-
employee
Right, because the Establishment Clause doesn't apply to everybody, but it should apply to the government, who's supposed to be able to welcome everyone. And that's what the public schools are supposed to do. right? They're supposed to be places where everyone is welcome. And so and it's with people advocating religion, it's harder for everyone to be welcome. But you're praying in a room in a university is not like my praying. And right, it's like my students praying is what they want to do, and it's fine. But it's different from my kind of leading them or encouraging them or coercing them to pray.
Daniel, thank you. Daniel, can you talk just a little bit? I know that the district tried to give him some accommodation where he was in a private area, and could you express why he didn't do that?
Sure. I believe as Coach Kennedy and the district were sort of going back and forth about what he would be allowed to do versus not allowed to do, they told him, one, you are not allowed to engage in any visible demonstration of religion where students can see you. You could come back after the game when everyone's gone, stadium's empty, or if you want to go up into the press booth and close the door, you can pray there. But anything that can be perceived by others as an expression of faith, you're prohibited from doing. Now, and the reason they did that is because they said that's the only way that we can protect the students' rights to either pray or not pray according to their own choice. Because if we allow you any visible demonstration of your own faith, that would send the message that basically the coach or the school district want the kids to pray. So we have to stop you from doing it to prevent the students from not being able to choose for themselves whether they, want to be religious or not. And that's what the Supreme Court, that logical leap from you're expressing your faith, that means that students who don't want to pray are excluded. That was the logical step that the court rejected and said, no, it's possible for the coach in a moment where he was free to do any number of things, if he chose to use that brief moment to pray, that didn't mean, just by virtue of the students seeing him be religious, that the students were impermissibly coerced into joining him. And that's the vision of a pluralistic society that I think we should strive for, where it's okay to be different from someone else. If you pray and I don't want to, or I want to pray differently, that's okay. You praying is not a threat to me. The flip side, saying that just by virtue of seeing the coach pray, that impermissibly coerces the students to join because they might feel like the coach would play favorites, wouldn't give them enough playing time. I don't think that inference is justified. Why would you assume that a religious person was unable to be fair in the way that they assigned playing time or what have you? If they hadn't done anything to suggest that's actually what they would do, why would you just assume that? Why would you assume by virtue of them expressing their faith that they would discriminate against people who don't? I don't think that inference is justified. I don't think the Establishment Clause creates that inference in our society, and I think that inference saying that it necessarily means that we can't trust a government official to be fair, I think that's much closer to the system that they have in France or in Quebec, where government officials are actually prohibited from wearing any kind of religious symbols, no yarmulke, no hijab. In France, even students in schools, no crosses, because it's a threat to others who might disagree with them. I don't think that's the pluralistic vision that the First Amendment set up. I think in our country, the vision was you're free to do it or not. And just by virtue of someone else expressing their faith, that doesn't coerce you to do it.
Okay. Thank you both for your comments, by the way. A couple more questions from the audience.
Is this turned on? Okay. So in respect to Professor Griffin, both of you are Professor Griffin, but Professor Griffin that I take classes
like
from.
Law firm. Griffin, and Jackson, yeah.
Yes. He has taught and said that to have true religious freedom, there needs to be some level of tolerance. I believe I get that quote, not exactly, but it's close. If I'm wrong, correct me. But my question is lack of religious activity from government people in government positions and offices in public places, is that a form of establishing a negative religious aspect? In that sense, not necessarily atheist, but like a negative religious aspect. And is that in some sense also a form of establishing a religion? And I'm not asking any specific one of you, but how is that not in a form of establishing religion? And how would it be if it was?
So if I may, we kind of have an aspect of hostility towards, and also maybe a secular religion being promoted, if I understand correctly.
I mean, Lemon uses a secular analysis test, and even though people think Lemon is dead, I mean, Justice Alito did write that the cross was a secular symbol, which I disagree intensely with that, but it was a different way of saying we can have public crosses because they're no longer religious, they're secular. But I do think the hope of the Establishment Clause is to have a government that isn't based on religion, and the word we usually use for that is secular. Now, I know many people have said, don't you realize secularism is also a religion? And so that's the battle on the losing side for me, because I think the court is right to say, with the Establishment Clause, we set up a government that isn't religious. Now, I think you're right. Many people perceive that as hostile to religion, but there is a certain hostility to religion in the Establishment Clause, right? I mean, right? And that's why I say people usually want to violate the Establishment Clause. Because from your religious view, you think, well, how can you think not having religion in government is a good thing? And the only answer I have is because the background to the Establishment Clause is wars of religion, where you always had people battling about what religion should be in charge. So the hope is that the government can be a secular government that protects everyone, and not a religious government that favors members of its religion over others.
Daniel, could you talk just a little bit, since Professor Griffin raised that, about this understanding of the Establishment Clause? Because as you guys know, later on, we get court decisions interpreting the Establishment Clause. So if you just kind of talk a little bit about that.
About standing under the Establishment Clause, is that?
No, as far as the court is going back to history and tradition.
Yeah. So as Professor Griffin laid out, the court had applied the Lemon test, which said you can't, in purpose or effect, advance religion, among other things. And they said we also look to whether government activity endorses religion. But really, from the beginning, back to the 1940s, when the Supreme Court first was interpreting the Establishment Clause, they always said that what they were looking to was what the Establishment Clause meant when it was enacted. They always at least purported to be looking at what the founders understood the Establishment Clause to mean. There was disagreement about what that was. Lemon didn't look at history as much, but at least it cited other cases that themselves had looked to history. And then in more recent years, the court has been much more explicit that the Establishment Clause must be interpreted in reference to historical practices and understandings. And in Kennedy, the court said, because the lower courts had still been applying Lemon, in Kennedy they said, okay, lower courts, enough is enough. Lemon's gone. We're serious now that you must apply the Establishment Clause in relation to historical practices and understandings. Now, the court didn't explain in detail what that will look like, and some people criticize the court. I believe in the dissent, they said, well, what are schools supposed to do now? They have no idea how to apply this historical practices and understandings test. I think that critique I think there's some merit to it, but I think it's a bit overblown. When the court makes any change in the law, they're not going to decide in that first case how that law will apply in every possible instance in the future. That's going to be left to future cases. That's the nature of common law reasoning that our courts engage in every day. So I think it'll be left to future cases to flesh out exactly what that historical analysis will look like. But the court did provide some very helpful signposts into what that might look like. As they were talking about this historical analysis, they cited the works of Professor Michael McConnell from Stanford, where he lays out his thesis that at the founding, an establishment of religion was a term that people understood because they were familiar with what established churches were. They had this established church in England. Most of the colonies had an established church, at least at some point. And so when they prohibited that, they knew what that meant. Established churches had certain characteristics, certain historical hallmarks. Things like the government controlling the doctrine of the church, the personnel, the government forcing people to participate in the state church, punishing those who didn't, punishing those who attended dissenting churches, the government giving preferential financial support to the established church or giving the established church a monopoly on civil functions, giving them government power. So the court, by citing to that work, at least foreshadowed what some of that historical analysis might look like, where we might look for some understandings of what an establishment of religion meant at the time of the founding. Again, citing to that doesn't answer every question. If you have, one of those aspects of an establishment but not others, does that mean it violates the Establishment Clause? Are some of them more important than others? It also, just pointing to that test didn't necessarily answer the question in this instance, because yes, everyone agrees no coercion, but this whole discussion we've been having is, what does it actually mean to coerce someone into participating in a religious exercise that they don't want to? So I think the court charted a course for where the Establishment Clause will go, and in broad strokes, what this historical analysis will look like. But it will certainly be up to future cases to flesh out the specifics of how that's going to happen.
My name is Harvey Neal. I want to basically ask you a couple of questions. Appreciate the presentation. Well, a couple of things are missing. One is the whys of the Establishment Clause. Nobody explained it. Why? How does the people of the United States benefit from maintaining that clause? Number two, there seems to be a lot of confusion about coercion. It's kind of a loose term. It fundamentally challenges and takes away the responsibility for making decisions. And that's what growth is about. Make decisions. When we stop people from praying, you are saying that in advance, I'll decide for you. This is not good for you. Don't listen to it. That is a fundamentally wrong position. Allow the children to hear. Let them make their choice. Because for one thing that I observed in the explanation of the Establishment Clause, always from the position of the judges and the government, but never gone beyond what religion is. Love God with all your heart and your fellow beings. Is it a crime, or is it wrong to love my fellow beings? That's religion. It's kind of built upon a very nebulous vacuum. So I'm asking you, it would be well to address the whys of the Establishment Clause and also allow people to make choices. That's what pluralistic society is about. Let every voice be heard and let the people decide. That's how growth is made and move forward.
Thank you. And let's go ahead and just really briefly, Daniel, I think you were talking a little bit about that a moment ago, why we have the Establishment Clause, but just a couple last thoughts on that to wrap it up.
Sure. I think the free exercise and establishment clauses are often portrayed as being at odds with each other. And I don't think that they need to be. Because when understood correctly, both have the effect of allowing religious individuals and communities to flourish, and also allowing people who are not religious to also form their own associations, live their own lives, make their own decisions, and they allow our country, which is composed of people who are very different from each other in religion, in background, in race, in politics, and so many different characteristics, it allows us to live together in harmony.
And I think what the Establishment Clause makes clear is that government religion does not promote individual religious freedom, right? If you've got a government that favors one religion over another religion, the individuals of different religions won't have freedom. And so I said it in my talk, right? The government doesn't practice religion so that individuals may have their religious freedom. And I think that's what we learned from the history of the Establishment Clause. If you try to have a government that's for everyone, then every individual is free to pursue her religion or not pursue religion, be an atheist or whatever religion you want to be. And so the fear is that government religion limits individual religion.
Great. Thank you very much. Excellent discussion. Thank you all.